All right. Well, let's get going. Today is March 17th, St. Patrick's Day. Just in case you're worried about it, I am wearing green socks, so I don't really have any green thing, green shirt, anything like that. Anyways, hope everybody's having a good day. We know several people have had problems getting on through our Eventbrite. Probably user error on my side, but hopefully we can get that cleaned up. We do send this out for people to see afterwards, so hopefully that helps as well. What I like to do is I roll through the information that we have in front of us, and then following that, if you have questions, you can send them via chat, and then we can just go through that way. There's been a lot going on this last year. We also get, as my team is focused on business and employment law, we get a lot of questions from business owners about just things that are happening in the day-to-day operations of a business. Sometimes those are directly and specifically legal. Sometimes they're things like, hey, how do we foster a better company culture? Hey, how do we motivate employees? Things like that. And, we were talking just the other day about those are types of issues that we want to discuss on this podcast. So next month, that's going to be one of the things we start bringing up is those kind of grilling questions on day-to-day operations of a business. How do you not only be compliant with the laws, but also how do you then facilitate a positive work environment for employees and motivate them in the proper ways? So looking forward to doing that. As always, legal disclaimers are something that we love as law firms. So here's my legal disclaimer. Obviously, in your specific situation, facts may differ. And so we need to talk to you individually in order to better understand your situation. Please give us a call. We'd love to help. The fun things have been happening in Arizona, as across the country they have been. Governor Ducey here in Arizona recently lifted the occupancy limit on specific types of businesses that had been hardest hit. So you have gyms, you have restaurants. Now, there are specific parameters still in place, which are social distancing, cleanliness, and cities have mandated mask wearing policies, and there's still compliance with that needs to be taking place. But the occupancy limit is a big indicator of where people are at with as far as when this coronavirus issue is going to be done. So we're excited to see on the back end, we might be close. Some other things that I've seen that I wanted to bring to people's attention in Arizona, but across the various states that people that we represent are in. When coronavirus hit, there was federal funds given to unemployment offices across the country in each state. In Arizona, there was an extra $600 given to the already existing $340, $360 a week that was available. They got these offices, unemployment offices, got inundated with these requests for unemployment. Well, guess what happened? They couldn't field all those requests and actually verify whether those were people that were real people or not. Well, now you have on the back end this huge issue of there's been a ton of fraudulent filings. Even on my team, on my side, we've had several people that we don't know, right? No, they're not employees. They never have been of my firm. We've had these filings come across. And most of the time, the way you find out is when your new unemployment rate comes out. And mine, as a new business, it was 2%. Well, it jumped up to 9.8. I said, well, that's crazy. We haven't had any unemployment filings. Well, we have, but we just didn't know about them. They were fraudulent. They never got kicked to us. We never were able to verify or to say, no, this isn't our employee. So a lot of people are dealing with that. We've got some templates and other things ready for people if they need help with sending a dispute or appeal letter to various state unemployment offices. So if you need help with that, please call us. Before you click send or click transfer money on your next, if you use ADP or any payroll service, please verify first with them, hey, what is my current UI rate, so unemployment insurance rate? And if it's more than what you thought it was last year or more than what you think it should be, let's talk, because you very well could be a victim of this. And that could be big money for people that have several hundred employees. Now, the other thing that is of note, it's kind of snuck up on us with coronavirus, is there's a new minimum wage in Arizona. It used to be 12, and that was the last time it was capped. We had 10, 11, 11.50, and 12. But what most people don't think about is it's actually set for a yearly increase. And so this year went up to 12.15. Next year will go up again. It's not set at 15 cents per year. It's just at a percentage rate. So please, if you're not seeing that you're compliant with that, please get in compliance with that right away. All right, so let's jump into the fun stuff. This is what we've been fielding questions on recently, and so I wanted to just kind of provide this information to those that are needing it. OSHA reporting. Are you as an employer required to report if an employee gets OSHA gets COVID at your workplace? Well, let's go through the analysis, and it's no different than an analysis that you go through with other OSHA-related injuries. So the first step is, one, you have to report if the case is confirmed case of COVID as defined by the Centers for Disease Control and Prevention. Two, the case is work-related as defined by a specific regulation. And then three, the case involves one or more of the general recording criteria set forth in the regulation. Now, there's many parameters within each of those, but I'll just say if there's a death, if there's days missed from work, those are easily within the parameters of when you would have to report COVID if COVID was caused by work. And that's one of the biggest factors that people are struggling with is, okay, I had an employee come in, they weren't COVID positive, they had exposure by a family member in a period, that they came into work, and then I have other employees that then got COVID, and was it from the grocery store? Was it from another interaction they had? The way we've been handling this is unless you can, or unless the employee can show proof positive that, hey, this came from work, or you show this was, most of us don't have contact tracing capabilities within our own employment situations. If you can show it came from work, then that is something that you start triggering these other items. If it triggers them from missing time from work, or worse, obviously, then that's something that we want to be aware of. Now, where do you report that? As each of you, unless you have 10 employees or less, OSHA requires you to keep 300 logs. And what that is if there's incidents at work, it could be unrelated to COVID, by the way, but COVID is what we're focusing on right now. If there's incidents caused at work causing employees to have health or safety issues, then those are reported on the COVID or the OSHA 300 logs. This is going to be a tongue twister today, I can tell. Hopefully everybody can follow it. So if you have specific questions on instances where you've had employees who have tested positive for COVID, have missed days from work, and you're not sure, hey, do I need to report this or not? Give us a call. We've walked through this analysis with several employers already. One of the bigger issues, though, I wanted to touch base with everybody on is back in January, one of the first executive orders issued by President Biden was, hey, we need to ensure the safety of our workforce. So OSHA, we need you to issue a new program that protects workers from coronavirus. Well, I think the concept is always great. When without getting too political, there are concerns, obviously, when you provide this type of mandate and then the program is initiated by a department that gets a lot of ability to come and inspect whenever and however they feel is necessary. So the program is supposed to be targeted at people who are most workers that are at highest risk. They put those at service industries, people that are, for instance, medical facilities, hospitals. There are other service industries. They've talked about warehouse facilities that have a lot of people coming in and out from different locations. A lot of times you think of lower income type of pay situations. That's a lot of times what the government will focus on. They're feeling like those people aren't being protected. So what is the program? It's a lengthy enough document. I won't go over the whole thing with you, but the thing that I wanted to highlight for you today is, one, it allows for unprogrammed inspections by OSHA. So what that means is, just like some of these other agencies out there, they can come to your place of business and say, hey, we're here and we're ready to inspect. And the things that they are looking for to who should they go and do these unprogrammed inspections for is, one, if there's been any reported fatality or catastrophe in the workplace, COVID related specifically right now. Two, have there been worker complaints? If you see what I see, it doesn't take much for a complaint to be issued by an employee right now with COVID, especially if that employee was working from home and now they're being forced to come back to work. There's a lot of people that have concerns about that. And so that can initiate complaints. Or three, this is my favorite because this is the most concerning, is referrals. I've seen this happen before where you have referrals from anonymous competitors, right? Saying, hey, this competitor I think is not complying. Now, that could be truthful or it could be tongue in cheek. And the problem with that is, whatever it is going to cause a large enough administrative burden on the employer who's having to face this investigation, because you have to set aside resources and time to accommodate the investigation, to provide all the documents that you have for them, and then to work around with your legal counsel and other people to ensure you're protecting yourself as a business from this investigation. So unprogrammed inspections I just went over. Second is programmed inspections. Now those are going to be for high hazard industries, and those are actually covered by specific NAICS codes. There's healthcare specific and non-healthcare specific industries that need to be on the alert. I can send out the links for that. It's not hard. It's actually found if you click on the program details. They have a list of those at the bottom, which businesses in healthcare and non-healthcare related industries are on the target for programmed inspections. The last is follow-up inspections. So those are, hey, for unprogrammed visits or program visits, who had citations? Who do we have concerns about? Again, I'll come back to my experience with inspections. We've done Arizona Department of Safety and Health, which is who facilitates the OSHA investigations for Arizona. I've done unemployment audits. I've done Department of Labor. I've never seen an instance where they don't find something, right? They don't find something that they can say, hey, we don't think this is all the way technically compliant. And I'll tell you the number one way they find that is by people not having posters, the appropriate law posters posted. So if I could give you one piece of advice, I'd say, if you don't have those law posters, contact us today, because we'd love to give you those so that you can at least pass the surface level of that inspection and not have a compliance issue from the very get-go. So dovetailing outside of these OSHA issues or things that may be coming out, is the biggest other issue we face is, as people are coming back to work, there's ADA, Americans with Disability Act, accommodations that people are requesting. One of them is, hey, I can't come back to the workplace. I have a health condition, or somebody I'm caring for has a health condition. And a lot of people are saying, well, because I worked from home for a while, I know I should be able to work from home now. That's not always true. Obviously, there were issues with coming to work for quite a while with COVID. And a lot of times the people couldn't perform the essential functions of their job while at home, but it was the only thing that the employer could do. So the question comes up, can a health condition exacerbated by COVID be grounds for reasonable accommodation? Now I've put in here, you'll see both physical and mental conditions can be exacerbated by COVID. There's many people that are suffering increased anxiety, depression, PTSD, other mental issues. And the answer is yes. If COVID does exacerbate underlying conditions already present, then that is grounds for, and can be grounds for, reasonable accommodation. What that is obviously a question of, we have to go through what's called the interactive process to determine what's a reasonable accommodation, what will allow the employee to still perform the essential functions of their job, and does it cause an undue hardship on the employer? The second thing we look at is working from home a reasonable accommodation? I've touched on this a little bit briefly, but not always. If work from home doesn't allow the employee to perform the essential functions of their job, so one of the key things I've found, I've advised multiple businesses on this point, if you have a front reception and their job is to not only intake calls, which can be done from home, but also to facilitate clients coming in the door, opening up the facility for people to come in, whatever that required, accepting mail at the office. Those were the essential functions of their job. Well, that means that job doesn't have to be allow for a reasonable accommodation of working from home. So it's on a case-by-case basis, but in large part, there's an ability to say, no, you have to be in the office if it's reasonable. There is a list of, and in this next slide, you'll see a couple other questions, but there's a list of FAQs that the EEOC puts out for ADA accommodations. Very helpful. They walk through an analysis on several points. So I'd say if you have questions, we will PDF this presentation. We can send it out to you. You can click on the links. They'll take you right to where you need to go so you know what you need to do. Does the ADA accommodation process apply to an employee who has a family member at higher risk of severe illness from COVID due to an underlying medical condition? This is actually one of the FAQs that was addressed. The answer for an ADA accommodation is no. ADA only applies to the employee themselves. It does not apply to a spouse, to a family member, a significant other. It applies only to the employee themselves. So it is not a reasonable accommodation to say, hey, my immediate family member has an underlying health condition that can be exacerbated by COVID, therefore I cannot go to the office. Whether you provide them the opportunity to work from home is a different question, but legally under ADA, that would not be required. If you meet a threshold for the FMLA, there could be some things like if they have to take care of a spouse and they need to be out from work, then that could be something, but not ADA directly. Can it be considered unlawful discrimination or retaliation for employees to be treated differently due to COVID-related issues that they experience? And the answer is yes. If an employee, for instance, this happens, and I've seen this not be directly litigated yet, but one thing that I've seen kind of on the horizon is, hey, Bill gets to work from home because he has an underlying COVID issue, but I have to come to work. Well, I as an employee am getting mad because I'm having to cover things that Bill would do, or maybe I want to work from home some, but Bill's doing it all work from home. Now I'm going to start sending mean messages or isolate Bill from conversations as an employee. That's a problem because the underlying accommodation is an ADA accommodation, which says the ADA laws say you can't discriminate or harass an employee for using an ADA accommodation. So again, just things to look at, things to think through when you're looking at these accommodations. Not only do you have to accommodate the employee, but you have to facilitate a communicate conversation with the other employees. You can't share, obviously, the underlying health condition, but hey, you cannot take adverse actions against people for these accommodations. All right, the big one. Can an employee as a reasonable accommodation, can an employer require its employees to be vaccinated? Overwhelmingly, the answer is yes, with some exceptions. If the employer requires it, currently there are workplaces that do require certain vaccinations already. If you work in the medical profession, you have to have certain vaccinations before you can obtain a job. So there are vaccinations that have been required in the past and that can be required now. However, if, for instance, let's say one of your employees has a lung issue and their doctor says, hey, getting the vaccine would cause some undue stress potentially on the underlying health condition that they have. Therefore, they can't get a vaccine. Well, you can't force them to get a vaccine, obviously, and you can't terminate them for that. Secondly is a religious purpose or religious reason. Those are kind of the two biggest ones that you need to look at. There are, even outside of that, reasons or ways that you could say, hey, you know what? In my workplace, you're going to have exposure, so therefore you have to be vaccinated. It's a safety and health issue for not only you, but other people. There are ways that it can be required, but again, those are the general exceptions that apply. Secondly, the bigger question that I've seen coming up is employees telling their employer, I will not return to work in the workplace until you require a vaccine. That's what we call hijacking a workplace. And unfortunately for the employee, it doesn't work that way. Now, the employee can say if there's unsafe conditions at work, like let's say, for instance, the employer takes no reasonable precautions to protect against COVID. They don't require any hand washing. They haven't provided any education on what could be social distancing or masks or anything like that. Maybe this employee would have a reason to say they can't return to work under OSHA, but under a reasonable accommodation, no, that is not a reasonable accommodation to require everybody else to get a vaccine before you return to work. So if you have that issue coming up, these are case specific again, so let's talk about it. The other thing we don't want to do is we don't want to retaliate against a person for requesting what they believe is a reasonable accommodation, because that very well could trigger Americans with Disabilities Act discrimination or retaliation claims. So let's talk about a few other items. One, employers can still use COVID-19 paid leave tax credit. That was a mouthful. Through March 31st. So while you're not required to provide the 2 weeks paid leave to employees who get COVID right now, you could if you wanted to. And up through March 31st, you can apply for and receive the direct payroll tax credit for doing so. So that's the 80-hour tax credit. The second is the employee retention tax credit. That applies to only specific businesses who have suffered certain percentages of loss over the last year. And if you say, hey, we retained our employees, even though we had all this loss of work, we didn't have enough work for them, there's that specific retention tax credit that's available. And then next is you have your first and second round PPP funding still available. And then lastly, you have your emergency disaster relief funds that are still available. So if you're suffering from or need assistance with funding right now, please, there's money available still that's waiting to be used, especially if you've had decrease in revenue due to COVID. So one of the questions always is, well, what should I do today? This is information that's sometimes it's overwhelming, but hopefully it's not. Try to break it down. What should you do today? One, the number one thing you should do is go check your unemployment insurance rate to see if you're getting charged too much, because that could be an instant instant savings for you, and it'll help you know what, if any, fraudulent filings you've had. Oh, sorry. Next is we need you to review your compliance for OSHA and ADA issues. What that means is OSHA actually is something that each employer needs to comply with. Not every employer has to keep the same records depending on the number of employees you have. But if you don't have your OSHA records ready and available, please get them ready and available. If you need us to come in and help you with that, we can. We have OSHA records available. We can come help you get compliance and set up. The other thing is with ADA issues. These are issues that pop up regularly that sometimes they're frustrating. People don't want to deal with them. Let us come in and get involved. We handle these all the time. We can help with the interactive process. We can help you know with certainty, hey, is this really a reasonable accommodation or not? Rather than on the back end, a lot of times what employers will do is just, I don't want to deal with it. I don't know, either let them have it or just tell them they have to come in or we'll fire them. And obviously that's not a great approach because that gets you in trouble. And then the last thing that we've dealt with a lot right now is partnership disputes. I've talked to several family law attorneys as well. Divorce is up. It's not that different than partnership disputes, which is COVID had either a boom or bust to a lot of employers. Boom meaning there was a lot of money coming in. Bust meaning they tanked and there wasn't a lot of things happening that were good. Either of those situations cause partnership disputes. When money is coming in, one partner wants to take the money out and go buy a boat. The other partner says, we're growing something. We need to put the money back into the business. It causes friction, it causes problems, or on the opposite side, obviously, if there's no money, it causes problems. So if you know of partnership disputes or agreements that need to be reviewed and modified to try to mitigate, a lot of times what we'll put in there is the actual trigger sale dates or sale times. What happens in the event that a partnership dispute, 50-50 partnership, you can't decide on what to do? Well, let's outline that so that we don't get to a point where you are at a true partnership dispute. The last thing I wanted to outline for you is the other services we offer at the firm, even outside of my team. We have a great group that does estate planning, wills and trusts. I was just talking to a firm downtown. They charge about $5,000 for a standard trust. Our team, I know, charges $1,900. So just even the cost, it's really not that expensive. That's for a comprehensive trust package. For wills, it's much cheaper. You can even get into durable power of attorney or healthcare power of attorneys, was what sometimes people need most. Those can be broken down. Bankruptcy and tax. We have a really great bankruptcy and tax guy at the firm. A lot of people, again, it's been a good year or a bad year, and either way, you're either paying more taxes or need to know what you need to do, or you're looking at bankruptcy as an option. Trust and estate litigation is called probate. We have that. Intellectual property, we do a lot of intellectual property in my team. Commercial leasing and negotiation, commercial property purchase, franchise review, dispute, and then another added service that we have is statutory agent. So if you have an LLC or a corporation and you are registered with the Corporation Commission in Arizona, you need to have what's called a statutory agent who can accept legal service for you. So really appreciate you tuning in. Again, I know several of you weren't able to join on due to user error on my side, and I apologize. We'll send out this this presentation, and hopefully it can be useful to you both on the OSHA and on the ADA compliance side. These aren't very fun topics. They're not things that you just say, "Oh, I can't wait to jump into," but they're critical because one, there's a new program with Biden that's going to come through, and we employers need to be ready. And then secondly, with ADA, it's not going away. People have become accustomed to working from home, and there's things that need to be worked through from the employer and employee side. So with that, I appreciate your time today. I'm going to give a quick second to see if there's any chat questions that come through, and if not, we'll go ahead and end for today. All right, thank you so much. If you need to reach out to us, you see the email there. Happy to help. Thank you, and look forward to seeing you next month when we go over some of the other questions we discussed. Corporate culture, how do you incentivize employees? And I think we might throw in a few tidbits on what you should look out for in non-competes. So it'll be fun. Thank you, everybody.